Hi, thanks for joining us today. We're coming to you live from Houston, Texas, from the office of Reddy Neumann, PC. We bring you the immigration updates every Tuesday at 5 o'clock Central Time. Today I have with me Rebecca Chen, who is a partner at Reddy Neumann, PC, and she'll be giving us an update on the America Competes Act. Where do we stand with that? What's in it? And what are the chances for it to actually happen? What's going on with these AOS cases that were filed in October 2020 versus those that were later filed in 2021. Issues with B2 extension applications that happened a lot during the COVID situation when people could not leave the US, and what the issue is there and how you can overcome that, as well as 7th year extension of H1B when you are getting to your 6-year limit and your perm is still pending. How can you get that 7th year extension? So let's go back to the America Competes Act. This stands for Creating Opportunities, I have to read it, Creating Opportunities for Manufacturing, Preeminence in Technology, and Economic Strength. What's the, what are the immigration provisions in this bill?
Right, so this was passed, so far it has only been passed by the House of Representatives, and it's in this form. It was passed last week, and it is a pretty sweeping bill, lots of economic provisions, but kind of the main immigration provisions of interest are, one is the creation of a new non-immigrant visa, the W visa, which would be for entrepreneurs. It's kind of known as the startup visa, and this has been proposed before by different congresspeople like Representative Lofgren. This would basically allow the owners of startup companies to apply for a W1 visa for a period of 3 years with possibility of extension, and to apply for a W2 visa for their essential employees of that business. Further extensions could potentially be granted based on the growth of the company according to certain benchmarks. So the visa itself is somewhat similar to, I would say, the E2 investor visa, which already exists but is limited to nationals of countries who have a qualifying E2 treaty with the US. So the E2 visa is not an option for large populations of foreign nationals who may want to start valuable businesses here in the US. Another important provision of it is the immigrant visa route, basically for people who complete a PhD degree in a STEM field. So obviously that includes PhD graduates from US universities, but it could also be PhD holders from foreign universities, as long as they will be working in the US in that STEM field. So this is a huge provision. It would basically eliminate the per country cap that prevents a lot of applicants from India and China specifically from quickly applying for the green card. So that would be a huge boon to researchers, innovators, people doing valuable research and development work in the US. It would really give a stable way for them to continue in the US, continue the work that they may have already started in the US, have been working on for several years, and allow them to continue to contribute to the US. So it has a lot of good provisions. A lot of people would say it's long overdue, but prospects for forward passage of the bill, what do you think?
So, the good news is the Senate actually passed the same bill, well, I can't say the same bill, but the similar bill in June of 2021.
Right. Mm-hmm.
So it's passed the Senate. Now the House has passed it. The problem is the House added all these provisions. So the Senate version didn't have immigration provisions at all. The House version added the immigration. It added stuff related to climate change. It's very broad and has a lot in it that was not there in the Senate bill. So when you have two different versions of a bill that were passed in each chamber, they have to come up with a reconciliation bill that both sides will agree on before it can finally be passed and be signed by the president. That's the major sticking point, because I think, the Senate was on board in June of 2021 based on the provisions they passed, but now that you've added immigration to it, I don't have good hopes for this bill passing. I would like to see it. I mean, there definitely has some helpful things, but you know, we're in an election year. I think that this is a way, you know, Democrats maybe purposefully added some of these provisions so they can say, look, we've done all these things, and it's the Republicans on the Senate that are blocking it. And so they get to blame the Republicans, and then the Republicans get to say, look what we did. We stopped this big reform bill from happening because it had all these extra provisions in it. So it's kind of more of a politic thing than an actual, we're trying to pass this legislation thing. Unfortunately, that's probably a cynical view, but I know a lot of people who watch this are sick of hearing of all these different bills that sound great and just never go anywhere. And I think this is probably going to have the same fate. What do you think about that?
Yeah, unfortunately, I mean, it definitely, this bill has would modernize a lot of the immigration provisions that haven't been updated since, you know, the last century, essentially. But yeah, kind of a realistic view of the prospects for the bill. It would be very difficult, we would think, for it to actually get passed and go forward, especially anytime soon this year.
All right. Now, another crazy thing that we're seeing with immigration is, you know, we had so many applications filed for adjustment of status in October 2020 when the visa bulletin had that big jump and Eb3 was further ahead. All these downgrade I140s filed with the 485. Those cases are still pending, many of them, especially all the downgrade ones where the date retrogressed. And then we have people that filed a year later who are already getting approvals.
Yeah.
You know, what is the logic behind that? Do you think, you know, does USCIS really follow first in, first out?
No, unfortunately. It depends on a lot of factors, and unfortunately the date of filing is not really a determinative one. What seems to be determining when an I-485 application gets approved, a lot depends on the service center where it was filed. As we've discussed on these sessions before, anything filed at the Texas Service Center in the last quarter of 2020 has basically just been stagnating there because of that particular service center. If the I-140 that the I-485 was based on is still pending, which is also happening for a lot of Texas Service Center applications, but potentially also because it was a downgrade and maybe the service center is not accepting a premium processing request. That is a factor because the I-485 can't be approved until the underlying basis, the I-140 is approved, or until you transfer it to another basis like Eb2, which you can do now but may not be able to until the priority date becomes current there. So I would say a lot of the I-485 approvals that we are seeing in this past year come from the National Benefit Center. That is where I-485s are filed if they are kind of standalone I-485s. If they're not being filed concurrently with an I-140, especially if they're filed based on an already approved I-140 where the priority date is current according to the final action dates chart, the medicals have been done, fingerprints have been done. That's where we're seeing I-485s going through with the National Benefits Center. So it is very frustrating that you know, we get emails, calls all the time that you know, this other employer, this friend of mine filed theirs last summer and it was approved, and mine that was filed in October 2020 is still pending. That is unfortunately the case for a lot of them, but those are kind of the factors that are at play right now.
And I think one of the common questions we get is, can I get my file transferred out of Texas Service Center? Is there any way to do that?
Not that we know of so far, or not that is available right now. USCIS has very strict rules on where you file each application type depending on where either you live or where your petitioner is based. So it could be based on geography, it could be based on whether it's being filed along with an I-140 application, whether it's being filed in premium processing. So those factors all lead into determining the one address that you can file your application at, and if you try to file it anywhere else, USCIS will reject it.
All right, next up, B2 extension. So during COVID, we had a lot of people where people were visiting the US on B2 visas, and COVID hits, and we have lockdowns in the home country, can't get a flight out, and the B2 status was expiring. So we told everybody at that point, well, don't let your status expire, file an extension. That's really the only option that you have because you can't get out of the country. So those that filed those extensions, they take forever to process. You can only request 6 months at a time. So many of those extensions were still pending. Some people filed another extension 6 months later because they still couldn't get out and they didn't have the approval of the first one. Fast forward, and at that time, remember, biometrics appointments weren't possible, so people were filing these applications that require biometrics but not getting any appointment. So a lot of people ended up leaving while those B2s were still pending, and then the biometrics appointment comes after they've left the country, and of course they're not going to fly back here to go for a biometrics appointment for a visa they don't need anymore. So the applications, some of them have been denied for not appearing for the biometrics. Now, there is a provision that says that if you file an extension of your B2 and you leave while it's pending, it can impact your B2 visa stamp that's in your passport. And for most people, we were not actually seeing that provision being carried out, and people were able to travel back on that same B2 visa later. But we're starting to hear a few reports, this is just a few, of people where they're traveling back to the US on that same B2 visa, and they're being turned away, sent back to their home country saying your visa is no longer valid because you overstayed back the last time you were here, even if they had the documentation that they filed that B2 extension. So is that, which of these interpretations is correct based on the technical guidance that you see?
Yeah, technically there is like you said, the provision that allows for the canceling of a visa wherever there is an overstay. However, in these cases, there was no unlawful presence. If the I-539 B2 extension application was timely filed, then even if the application was not ultimately approved, if it was pending the entire time the applicant was in the US after the I-94 end date, they were in a period of authorized stay the whole time. So it may not have been actual status, but it wasn't unlawful presence. It's kind of an in-between period called a period of authorized stay. And so normally what we're seeing is if the returning visitor has the I-539 receipt notice, and it's clear from the dates on that it was during, the height of COVID, where everyone knows you were not able to get a flight out of the country, or it was not safe to do so. Mostly we're seeing those applicants being still admitted, but in some cases we're hearing of CBP considering those visas canceled. So for people in that situation, how would they know if that's their situation before they travel?
Yeah, that's the difficult thing, is the consulates cancel visas. It happens quite often for various reasons, but they don't send you any notification. Or if they do, it's an email that probably looks like junk email, and so you probably never got it or saw it. And we don't know if there's really a good way to contact the consulate and ask them, hey, is my visa still valid? Because number one, they're taking forever to respond to anything. And number two, if you're asking them, maybe that is going to lead them to invalidate the visa.
Yeah.
So it's kind of, you're stuck between a rock and a hard place. And if you are concerned about that and planning travel, one thing that you could do is go ahead and just apply for a new visa stamp now. Even though your visa stamp has not expired, you probably have the 10-year visitor visa, go ahead and apply for it, especially right now because we have the Dropbox availability, and that only lasts till December for a lot of these applicants. So you could apply for a new visa stamp, bring that documentation in case they ask for it to show that you did timely file that I-539, and that way the next time you travel you'll have that new visa and don't have to worry about it. All right, last topic we wanted to talk about is 7th year extension of your H-1B. So a lot of you know that once you have an approved I-140, if your priority date is not current, you can keep extending your H-1B for 3 years at a time until the date becomes current. That allows you to file the 485. But what happens if your I-140 is not yet approved? Then we go to the 7th year extension provision of AC 21, which allows you to only extend for 1 year. But that only works if your labor certification has been pending for 365 days. So we normally tell people, make sure your labor certification is filed before the end of your 5th year so that you can use it to get an extension beyond the 6th year. But there are people that are stuck in a situation that they file the labor certification while they're in their 6th year. And in the past, we would always hope that the labor certification would get approved during that time and we'd be able to file the I-140 during that time, and then you could get a 3-year extension. But what happens now that labor certification processing times are much longer than before, or the labor gets audited? Is it still possible to extend beyond the 6th year in that situation?
So if the H-1B beneficiary has any recapture time that they can use, meaning time that they've spent outside the U.S. since they started in H-1B status. So any time spent outside the U.S., you're not technically in H or any non-immigrant status at that time, and you can actually file an extension to extend your H-1B status by the exact number of days that you are outside the country, and you would just provide a list of your travel dates, calculate that out. But if you are also out of any recapture time from travel outside the country, in most cases it does require leaving the US. So we have had situations where clients have had to depart the US for a short period of time, hopefully, no more than a few months, where, their final 6-year limit, including recapture time, has run out. But because of DOL processing times, the perm is not going to be approved until maybe 3 or 4 months later. And so usually the the easiest scenario in that situation, rather than trying to change to some other status here in the US, a lot of people choose to wait outside the US for the perm process to continue processing, because they may be able to arrange to work remotely for their employer from outside the US at their home country. In those situations, if we know that we've already decided that the client is going to wait outside the US to finish the perm processing, we could actually file the H-1B application requesting that 7th year, maybe even before they depart the US, but putting a start date on the I-129 form of basically the 1-year mark from where the perm was filed. So we would put a future start date where at that point the perm would have been pending for at least 365 days. So at that point, a few months in the future, the applicant will qualify for that 7th year, but we file for it now, maybe even before they leave the US. It won't fix the problem of maybe needing to depart the US, but the benefit of filing that way with a future start date is that you can get the H-1B petition approved and apply at the consulate, already start to put in at the consulate for a visa stamp appointment or the drop box, because one of the main problems at the consulate now is drop box availability or in-person appointment availability. So it gives you a head start that once you do reach that 1-year mark, you may be able to return to the US as soon as possible without having to wait for an additional H-1B processing time and waiting for a consulate appointment.
All right, yeah, that can be a big benefit because, number one, you have the H-1B that you need to get filed and get approved, which can take a few weeks, and then waiting outside the US and then applying for the stamp. When are you going to be able to get that appointment? You could save someone maybe 6 months or so by doing all of that in advance before you actually meet day 365 of when the perm was filed. So that's another thing to keep in mind if you have that option, if you don't have the option of recapturing or changing status to another type of visa. All right, let's get to some questions. Sudhakar says, my EB2 I-140 has been approved with company A, and then that company merged with company B. You did a downgrade from EB2 to EB3 already. That I-140 is approved, but now to interfile to EB2, does the I-140 need to be amended? It sounds to me like yes, because you know, the I-140 is only valid for the company that sponsored you, and so because that company merged into another company, the new company has to establish that it qualifies as a successor in interest before you can take advantage of that EB2 I-140. So for that, it does require an amendment by the new company documenting that they are a qualified successor in interest, that they have the ability to pay, that they're offering the same job under the same terms and conditions, same work location, same salary, and all of that, and that you still qualify for the job. But once that amendment is filed with this new interfiling guidance, you do have the option of interfiling the EB2 to the pending I-140, or file it, get it upgraded to premium, get the approval, and then do the interfiling. I think either of those would work, but it sounds to me like it does need an amendment.
Premanon from YouTube is asking for predictions about EB3 in 2022. So as far as movement of the dates, we always are hesitant to make predictions on how the visa bulletin will advance, but what we can say is that based on visa bulletins that have come out so far this fiscal year and statements on the USCIS website that are basically encouraging people to transfer the basis of their eligibility to EB2 if that's a possibility for them, that seems to indicate that at least for the rest of this fiscal year, I would not expect EB3 to move forward any more than it is now, and it hasn't. You know, the past few months there has been no forward movement in EB3, and that is likely to continue for the rest of this fiscal year at least. It remains to be seen what will happen next fiscal year. In October of this year, it is always possible that so many people have kind of now in this past year shifted from EB3 to EB2 that it may have reversed the you know, the status of EB2 and EB3 to where EB3 starts becoming more farther advanced than EB2. As we said before, those lanes kind of flip-flop a lot because people are moving between the categories.
All right, Joy wants to know if we've received any receipts for the 485J supplement filed to this new California address. How long is that going to take, and how will they process the 485 after that? As far as I'm aware, we have not received any receipt notices for cases where we used this new interfile process and filed at that new California location. We only started using that, you know, probably the Monday after that Friday announcement came out, so it hasn't been long enough for USCIS to issue receipts normally, so I'm not surprised that we haven't started seeing those yet. And as far as the process after that, no one knows because it's never been done this way before. We would hope that USCIS has the capability to send that information electronically to the service center where your application is pending, and that officer will adjust it from EB3 to EB2, and then if the date's current, which it should be, proceed to adjudicate the application. That's what we hope will happen. I think that's what they plan on happening. Will it actually work? That remains to be seen.
Barath from YouTube is asking about how to get USCIS to accept a premium processing upgrade request, which his employer has sent in 4 times now, but which has been rejected each time because the original perm wasn't available. So this is unfortunately the situation for a lot of the downgrade I-140 applications that were filed at the end of 2020, especially those pending at the Texas Service Center. Basically, USCIS needs the original labor certification in its file in order to put an I-140 case in premium processing, and the original I-140 for a lot of those downgrade cases are in the EB2 file from several years ago somewhere in USCIS's storage that they have to go retrieve. Unfortunately, in our experience, we haven't really seen a particular way to compel USCIS to locate that original perm and add it to the file and to accept a premium processing request. We have just been continuing to send in that $2,500 check with the I-907, you know, every 30 days or so, or however long the rejection notice says to wait until trying again. And in some cases we have had success. We did have a case that was accepted for premium processing after, I think, over a year of trying to upgrade it to premium processing recently. So it can happen eventually, but unfortunately we don't have any particular trick besides continuing to try.
Pakala Prasad says his daughter is protected by CESPA, the Child Status Protection Act. Also applied for an F1, which was denied due to some mishap with the SEVIS record being canceled, and wants to know, is it okay to not attempt to do an MTR or a motion to reopen that denial? So, so this is a situation where I'm assuming your daughter was in H4 status, filed the 485 as a dependent before turning 21, either based on the real age or the CESPA age. That means the I-140 is approved, and the final action date became current before she turned 21, whether the real age or the CESPA age. And now, before turning 21, filing a change of status to F1 to have that as a backup plan in case something goes wrong with the 485. In this situation, the F1 got denied. So if the age is locked in truly under CESPA, then it is not necessary, it's not 100% mandatory for the child to convert to F1 status in order to stay in the US. They can instead rely on that pending I-485 application. That keeps them in a lawful period of stay. It's not a status, but it is lawful presence. They have the EAD, they can use the EAD to work, attend classes, get the driver's license, everything they need to do. They have the advanced parole, they can travel without needing to get an F1 visa stamp. So in many situations, it's not necessary once the child's age is locked for them to convert to F1. You can instead rely on the adjustment of status.
The shop from YouTube is asking about the processing times for I-485s comparatively between Texas Service Center and the National Benefit Center. So as we mentioned earlier, there is a huge difference in processing times depending on whether the I-485 is at one of those service centers. At the National Benefit Center for, like we mentioned before, standalone I-485s that are based on an already approved I-140 where the final action date is current for that case, we're seeing approvals sometimes within 6 months, sometimes even a little less. And it's just an entirely different story at the Texas Service Center. Cases are pending there from the end of 2020, even before the end of 2020. We have some cases that were filed in the summer of 2020 that are still pending at the Texas Service Center. So it is definitely out of hand at the Texas Service Center, and they need to do something to fix that. It can't continue indefinitely. And Ashok is also asking, do we think USCIS will use all the employment-based visas this year? Our hope is that they will. Whether they will remains to be seen. We're hopeful. I would say the policy update last month on transferring your eligibility basis from EB3 to EB2 seems to indicate that USCIS is looking at it, and at least looking at it earlier than they did last fiscal year, where they waited until the last quarter. They're looking at it earlier now and seem to be doing what they can to process as many I-485s as they can before the end of September. So we're hopeful that they won't waste green cards this year or as many.
Sabari did a downgrade from EB2 to EB3, has the I-140 approved, has the EAD and AP based on that, but is only valid for a year, so it's coming up for renewal this March. Now she wants to know, if I interfile to EB2, can I still renew my EAD in March? And is it based on the EB3 485? Will that EAD remain valid? Yes, the EAD and AP remains valid. So what makes you eligible for an EAD and AP is simply having a pending 485. It's not necessarily tied to a particular I-140 or visa classification, meaning EB2 or EB3. Just because you have a 485 pending, you're qualified for an EAD and AP. And because your 485 will continue to remain pending, you are eligible to renew the EAD and AP, regardless of whether you're interfiling to transfer to EB2 now. So you can go ahead with that. the existing EAD remains valid. The renewal can happen as a normal renewal. No worries there.
Manjushri is asking if their child, who is 20 years old, it sounds like they are already on an F1 visa, do they need to be in H4 status in order to apply for adjustment of status? So the answer is no. You don't need to be in H4 or in H status in order to file the I-485 application. So in your child's case, they can file the I-485 as the derivative applicant of you or your spouse once you're eligible to, so you can file as a family. The only caveat that we kind of usually warn people about of F1s applying for adjustment of status is to be careful with international travel. We usually recommend that people in F1 status not travel internationally once the I-485 is filed, because unlike the H visa, the F1 is still a temporary visa that does not allow for dual intent. Technically, it doesn't allow you to have the intention to stay permanently. When the applicant remains in the US from the time the I-485 is filed until it's approved, or at least until they get the advanced parole, we've never seen any problem with the intent issue come up during the I-485 processing. But there is a possibility that you could be questioned about it when trying to re-enter the country on that F1 visa. So as long as they will not be traveling internationally, that will be fine.
Harry says, my U.S. citizen spouse, if they file an I-130 for me under the family-based immediate relative category, and I concurrently file a 485, do I still need to maintain my H-1B status to continue working in the U.S. until my family-based green card is approved? So you're not required to continue to maintain the H-1B status once your 485 is filed. The 485 puts you in a period of authorized stay, so you can remain in the country. However, you won't have any work authorization besides your H-1B until your EAD gets approved based on that pending 485, and that can take a good 8 months to process. So if you want to be able to keep working while your 485 is pending, you would need to stay on your H-1B until you get the EAD, and then from that point, assuming it's a clean, straightforward case, family-based, that you expect to be approved, then it would be safe to move off of the H-1B and use the EAD to work from there.
Siva Kumar from YouTube is asking, how could we know how many perms are in the EB2 or EB3 category each year from 2016 forward? How many are pending, approved? So that is the difficulty with trying to calculate or predict the priority date movement in these categories, because one issue is, even if we have data that shows from DOL how many perm applications were filed and approved in each year, we don't know how many of those are for the same applicant. So when an employee has a perm filed and approved, if they move on to a different employer, they may have the perm process started again for them. They may have perms in more than one category if they initially filed in EB3 and then moved to the EB2 category. And so there could be multiple perm applications for a single applicant who would use just one immigrant visa number. And I don't think even the Department of State or USCIS have clarity on, how many cases there are like that, which is why sometimes the visa bulletins are kind of unpredictable even for them. Sometimes they set a date in the visa bulletin just to, as they say, kind of gauge demand for that category, see how many applications come in. They don't know for sure until they get the I-485 applications in either. So, so there is a lot of uncertainty in those calculations, unfortunately.
Surya Narayana wants to know, if I go for transferring my underlying basis to EB2, my children's age was locked under the EB3. Is their age going to be locked under EB2? So we don't have any formal guidance from USCIS on this, but I think most likely the answer is no. They're not automatically locked in EB2. And the reason for that is, at the time you filed their 485 in EB3, the EB2 final action date was not current. So their age does not get locked based on the time you filed the 485. So now you have to look at CESPA all over again based on when the EB2 final action date became current. Based on that date, what is the child's age, and you can subtract the number of days the EB2 I-140 was pending when you got it way back when. So you have to look at how long that I-140 was pending. Does it allow you to subtract enough dates from the age at the time the EB2 final action date does become current? And if then they're under 21 at that time, you can transfer and their age is locked. So there's a lot to consider there, so definitely talk with an attorney to make sure that their age will be locked before making that switch to EB2, because you don't want your kids to lose out on that opportunity.
Sarabi from YouTube is asking about a situation where she has an EB2 I-140 already approved. It sounds like a downgrade I-140 was filed in October 2020, which is still pending, but an I-485 was not filed at that time based on that I-140, and whether they can file an I-485 now based on the approved EB2 I-140. Definitely yes. You don't need to wait for the EB3 I-140 to be approved. You can sort of just ignore the EB3 I-140. It doesn't affect your ability to file an I-485 based on the approved EB2 in any way. Because you haven't filed the I-485 yet, you don't need to request an interfile or anything like that. You can just file a new I-485 based on the EB2 I-140.
Manisha wants to know, what is the process to change from a Gc Ead to H4 Ead? In this case, her Gc Ead is about to expire, but the H4 and Ead were finally approved recently after she started working on the Gc Ead. We're seeing this a lot right now. So once you've used the Gc Ead, you're no longer maintaining your H4 status. But if you later get your H4 approval notice and your H4 Ead, you can get back into H4 status by traveling and using automatic revalidation, even if your underlying H4 visa stamp has already expired. So in that situation, you travel to Canada or Mexico for less than 30 days, you don't go for stamping, and when you return, you show your expired H4 visa stamp and your new I-797 approval notice for your H4 that has an I-94 on it, and then they'll readmit you in H4 status. And once you're back in H4 status, now your H4 Ead becomes active and you can start using that.
We have a question from YouTube on what are the criteria for getting an interview for your green card application? Why do some people get an interview request and some don't? For employment-based I-485 applications, the majority of applications we're seeing are not requiring an interview, even though the kind of Trump administration policy of mandatory in-person interviews for all I-485 applications, technically that is still in place and hasn't been removed yet. But what we are seeing is that since 2020, due to COVID, USCIS in most I-485 employment-based cases are waiving the in-person interview. They always reserve the right to call someone in for the final interview, and in our experience, what we're seeing is you are more likely to be called in for an interview, definitely if there are kind of significant immigration violations in your history, if there were periods of unlawful presence or overstays, if there is criminal charges in your history, which all would have been hopefully disclosed on the I-485 application already. If your current employer or a previous employer who filed an I-140 application on your behalf had any issues with USCIS where they were ever investigated by USCIS, we do see people called in for interviews just to confirm whether, confirm that that employee had nothing to do with anything the company was engaged in, the reason for the investigation. So those are some criteria, some factors for why you can be called in for an interview. In our channel, we actually have a separate video that we did on I-485 interviews specifically with Rahul, so you can always take a look at that, where we discuss when and why you would get an interview and then how to handle that situation if you do have an interview.
Barath says, I had visa revalidation done and got my H4 I-94 extended, but the original H4 also got approved and I haven't interfiled it. what happens to the H4 Ead, which is pending. So I'm assuming after you came back in, you got a new I-94 number, and then your H4 extension later got approved with your old number on it, but your EAD is still pending. So nothing should happen out of the ordinary with that EAD. It should eventually be approved since you got H4 status by traveling, as well as your H4 extension was eventually approved. Usually it is approved at the same time. So it's very possible that it was approved and the online case status didn't update. Otherwise, it's kind of unusual if they don't approve them at the same time unless something was missed and they send an RFE. But it should be processed as normal. And then as far as the different I-94 numbers, that will get cleared up the next time you travel because you'll be issued another I-94 number when you return.
Neil from YouTube is asking if you do transfer the basis of your pending I-485 from Eb3 to Eb2, can you still use the EAD and AP card that you received based on the pending I-485? And the answer is yes. The EAD AP is not contingent on the EB2 or EB3 category that the I-485 is based on. The only time where we caution against potentially using the EAD or AP that you received from the I-485 is if you are intending to maintain your non-immigrant status. If you're planning for whatever reason to stay in H status, maybe because you have children who are nearing the age of 21 who are dependent on your status. If you are planning to stay in your non-immigrant status, then that's where we caution against basically don't use the EAD AP because that could basically void your non-immigrant status. But transferring the basis from EB3 to EB2, as long as that I-485 is pending, then that EAD and AP are still valid.
Damadaran says, are we allowed to move to a management position using the EAD and AC21 with the supplement J, even though the original labor was for an individual contributor in the same field many years ago? When do we file the 485J and how long for receipts? So yeah, there is a provision, it's in the policy manual at USCIS's website that says that a lot of times a promotion is eligible for AC21. They have some different factors that they look at. Are you using the same types of skills that you were using? Are you supervising the same type of people that the position you were originally sponsored for was done for? So it can be possible. Once you submit that supplement J, we're seeing receipts coming within a month, I would say. It's not taking extremely long right now. And you would file that supplement J. Usually, it depends on the company. Some employers say, I'm not going to submit it unless USCIS asks for it by sending a request for evidence or you have an interview scheduled. Others will file it around the same time that you make the switch into that new position. So either one generally works. So it kind of depends on the employer and what their attorney is advising them.
Uma is asking if filing for the Social Security number for a child can be done with the I-485 application, or should it be applied for separately after the EAD or GC is issued. So you can apply for the Social Security number now as part of the I-485 application. That was an update to the form just last year. There's a section on it where you can check whether you want the Social Security Administration to issue you a Social Security number, and you have to provide some security info, but you can request the Social Security number as part of that form rather than applying for it separately later. And then Dheeraj is asking, can you file a change of status from F2 to H1B within the US using an approved I-140? So that is a situation, kind of as we were discussing before. It sounds like this person ran into the 6-year limit for their H1B status and was still waiting on the perm to be approved, and now that has been done and the I-140 is approved. They're eligible for the additional 3-year extension beyond the 6th year. But instead of departing the US during that interim, Dheeraj changed to F2 status, which is fine too if you can manage that or planned ahead and made that change beforehand. And yes, that's fine to apply for a change of status from F2 to H1B now. The only thing that we kind of recommend is kind of being careful about the most recent date of entry using the F2 visa. For any entry on an F visa, if you apply for a different visa status too soon after your most recent entry, USCIS can kind of scrutinize that and look into whether you had genuine non-immigrant intent at the time of entry. But if it's been at least 3 months since your most recent entry on F2, or if you never used the F2 visa to enter, if you just changed status using the I-539, then you can change your status to H1B at any time.
Bhaskar has his home address listed as one of the work locations on his H1B and LCA, and now he's working for a different client. The client is located in another state that's more than 50 miles away from his home, but he's still working from home and wants to know if an amendment is necessary. No, it should not be necessary because the LCA that you submitted previously is for your home office location and your location is remaining there. Now, if you do later go into work at that new client location, before you do that, an amendment would be necessary. But if you're continuing to work from home and you have not moved your home address, an amendment should not be required.
Arthur is asking, can concurrent filing of an I-140 and I-485 affect the I-140 processing time? Not really. For the I-140, what mostly determines the processing time is whether it is a subsequent I-140 filed on a previous perm application, or if it's basically the first I-140 being filed on that perm application. If it's a subsequent filing, like the downgrades, as we mentioned earlier, USCIS usually won't accept a premium processing upgrade request right away because they have to go locate that original perm from the prior I-140 file. But if this is basically a newly approved perm application and the I-140 is being filed based on that, then you can apply for premium processing and that can get approved within 2 weeks. If it's in regular processing, it could take much longer, close to a year potentially, but those are the main factors that determine I-140 processing times, not whether it's concurrently filed with an I-485. The reverse is not true though. Whether an I-140 is concurrently filed with an I-485 can determine how long the I-485 takes to process. So we mentioned that earlier too. If you file the I-485 separately, it goes to the National Benefits Center. So the concurrent filing affects the I-485 processing time mostly because it dictates which service center the I-485 gets sent to. So if you have time to file the I-140 separately, get it approved, and then file the I-485 on its own with the National Benefits Center, we would usually recommend that.
Ship says he downgraded from EB2 to EB3 in October 2020 and of course was disappointed after EB3 retrogressed, but then last week received a medical RFE. He wants to know, is my case still progressing and can I get the green card with these dates retrogressed? So USCIS can continue to work on the I-485 applications even when the date is not current. They generally will try to get it approval ready, so they'll complete all of the background checks, make sure the fingerprinting's done, make sure all of the birth certificates, marriage certificates are there, and have it ready to hit the approval button as soon as the final action date does finally become current. So that's not unusual. At the same time, does it mean you can actually get the green card when the date's retrogressed? Most likely no. There are a few situations where a visa number was assigned before the date retrogressed, and that allows the officer to still approve the green card even after the date's retrogressed, but that's not very common, and it would be unusual for that to happen so many months after the date's retrogressed.
Raul from Facebook is filing the green card for his parents and they don't have birth certificates, which is common for people past a certain age who were born in India. The records just were not kept at that time. So for proof of their birth, usually we recommend getting a non-availability certificate from the government authority there in India that confirms that there wasn't a birth certificate filed for this person. That plus at least 2 affidavits from family friends, people who can confirm where and when they were born, and then anything else they happen to have from that time. If they have school records or anything else from when they were growing up. If they don't, that's fine. I would say the non-availability certificate plus 2 affidavits of birth would be enough for the I-485 application. We have a video in this channel on that subject alone about what to do if you don't have the birth certificate for the I-485 application.
Maruthi says her visa stamps expired in 2019. H4 and EAD extensions, those are expiring in April of this year. H1B extension is already approved, but of course the H4 and EAD are pending. Any risk in traveling to Mexico for 3 or 4 days and returning with automatic visa revalidation? And there's always risk with travel. I have to give you the lawyerly answer there, but we do have a lot of people that have had success when they travel by air to Mexico and return back before the current H4 expires, and they provide the spouse's H1B extension. They have been getting the extended I-94 in the H4 status, which allows you to then take advantage of the 180-day automatic extension of your EAD, which will hopefully allow your EAD to be approved during that time so you don't face a gap in employment.
We have a question from YouTube from a father whose green card was approved last year, and their child's I-485 is still pending, but the child's age was locked via CISPA, and they're asking is there something going on? Is the application going to be denied for some reason? I would say there should not be any problem. We haven't seen any child applications being denied if they were locked in for CISPA and the age is fine. We have been seeing cases where families who file the I-485s all together for some reason don't all get approved at the same time. So that is happening occasionally. The principal applicant, sometimes in maybe one child or the spouse only get their approvals, and then a spouse or child has not yet gotten their approval, sometimes for months, for 5 or 6 months sometimes. And we don't really know why it comes through eventually, and kind of all you can do is try to maybe put in a service request if it is beyond the normal processing time. What it seems to be, I think we had heard somewhere that officers, in an effort to improve efficiency in processing, were splitting up case files to process, but splitting up families so that one officer maybe has the parents' files and one officer has the child's files, and the parents' officer is processing faster for some reason. It does not make sense. It's just USCIS's inefficiency, I would say, but I would say there isn't really anything for the child to be worried about. It should be approved eventually. In the meantime, I know you're asking, should that child stay on F1 or can they start using the Gc Ead? That is also hard to say. I would lean towards being safe and maintaining the F1 just in case something happens with the I-485, although I understand that's difficult if the child has a job opportunity that they want to start working. If they can maintain the F1, I would recommend it.
Narian says, is it normal after the fingerprint fee was received if the status on the USCIS website doesn't change for 3 months for the 485 process? Yes, that 485 online case status really only changes when something happens, like sending a notice to you, like your fingerprint notice, or scheduling you for an interview, sending an RFE, or sending the approval notice. All the little steps that an officer does in between, you won't see any update on that. And a lot of times the status doesn't update at all on the USCIS website. It is a glitchy system. I would recommend, if you don't have it already, getting a My USCIS account and checking the status there, because sometimes when the normal case status website doesn't show any updates, the My USCIS account might, but that is very normal, so I wouldn't be too concerned about it. And another question on that, Aravel says, it's been 1 year since fingerprinting for a marriage-based AOS and no update yet. Yeah, that's normal too. A lot of the marriage-based cases are taking closer to 2 years now. A lot of that is because the local offices have limited capacity because of COVID, and so they have fewer appointment slots available. So it does take longer for that appointment to be scheduled. They have a big backlog of all the cases that were filed during COVID through all of 2020. So yeah, it's totally normal that it's been a year and still nothing happened.
Manoj is also nearing the end of his 6-year H-1B limit. Luckily, he has the approved I-140. It says his company is a little behind on preparing the H-1B extension and what are the options if it doesn't get filed in time. Mostly just try to get it filed in time at this point. The H-1B extension does not need to be approved before your I-94 expires. It just needs to be filed. So at this point, if you still have a month before your current H-1B expires, just put pressure on your company to get the LCA certified and file the application. As long as it arrives at the service center before your I-94 end date, it is considered timely, and even if it is pending for several months after that, you're in a period of authorized stay. You can continue working for up to 8 months beyond the I-94 expiration date. So they don't even need to file in premium processing if they don't want to. They just need to get it filed on time.
Kieran says, I got my birth certificate recently and heard from some friends that I need to get an affidavit also. Can you please clarify? So assuming your birth was registered late and you're just now getting the certificate, USCIS does usually ask a lot of times in an RFE for secondary evidence to verify that that birth certificate is accurate. So affidavits are one form of that secondary evidence. You don't necessarily have to get the affidavits before you file. Like if you're ready to file your 485 tomorrow, go ahead and file it tomorrow. And if they need that secondary evidence, they'll send the request for evidence for it. But if you're not planning to file right away and you have time, you could go ahead and get the affidavits, but also submit other secondary evidence along with those affidavits. That can be school certificates, that can be hospital records, it can be a PAN card or something like that. So there's, I think we have an article on that on our website. If you search for birth certificate, you should be able to find that. What are the secondary documents that can be submitted along with the affidavits?
And Petrus is asking about changing from L1A to H1B status. I can't really tell from the question if they have already been selected in the CAP or are just going to be submitted in the lottery this year. Either way, if you are concerned about kind of the transition from L1A to H1B, basically if you file the H1B application as a change of status with the start date as 10/1, if you are in the country at the time, basically your status will automatically change from L1 to H1B, which may not be an issue for you if you're working for the same employer. It could have effects on your spouse, for example, if they have an EAD that they're using for L2 status, and maybe the H4 EAD may not be approved at that time. One way to have more control over when your H1B status changes over is to file the H1B in consular processing. Then your status won't change until you go for visa stamping for the H1B and re-enter the country, so you can kind of plan that transition better.
Sarvesh says, would filing the 485 Supplement J to upgrade to EB2 again reset the clock for job portability? According to the USCIS policy manual, yes, it does. So once you do that interfile to switch back to EB2, you have to wait another 180 days before you're eligible for AC21 to switch jobs. Now, do they have the authority to make that kind of statement? That's a little questionable, especially where the EB2 and the EB3 are with the same employer. So if someone were to eventually get a 485 denial because they ported before 180 days after the Supplement J, I think that could be litigated, but I probably don't want to risk losing my green card because of that, and it would be best to wait the 180 days. Well, I think we're out of time for today. Thanks so much for joining us. We hope you found this helpful, and we will be back next Tuesday with more news and answering your questions. And you can always get information by signing up for our weekly newsletter. We send that out on Wednesday, so you can go to rnlawgroup.com to get signed up for that.